Welcome to Learn About Law. My name's Kevin O'Flaherty from O'Flaherty Law. Today we're going to talk about major issues between condominium associations and condominium unit owners. So basically a high-level overview of Illinois condominium law. If you want to see more articles or videos or our podcast, you can go to learn-about-law.com, where we've got articles on nearly every subject of law. So to get started, I want to talk about the type of law that governs disputes between condominium unit owners and condominium associations. There's a couple different areas of law that an attorney has to look at to find out what everyone's rights are. One is the Condominium Property Act of Illinois. That's the statute that lays out the rights between all the parties. Another is the Condominium Declaration. That's the document that created the condominium association in the first place. Another are the bylaws, and that's usually how they lay out how the board is supposed to manage the condominium association. And finally, there's the rules and regulations that are imposed by the board upon unit owners. So this is basically dealing with how unit owners are supposed to act with one another. Finally, the Illinois Not-for-Profit Act applies to condominium associations as well. So they're supposed to be not-for-profit corporations. So any rules laid down by the Not-for-Profit Act of Illinois are also going to apply in condominium situations. So one of the most common disputes between a condo owner and the condominium association is when a condo owner is in default of their dues or some other obligations imposed by the association. So if they're late in paying an assessment, the condo association has all the rights imposed by the Illinois Forcible Entry and Detainer statute. So that's basically eviction. So whenever a landlord evicts a tenant, they do it under the statute. Condo associations can do the same thing for unit owners. They can put a lien on the property so that the unit owner isn't able to sell the property without paying off its dues. They can also go into eviction court and evict the unit owner if the dues aren't paid. The next big dispute between condominium associations and unit owners I want to talk about are breach of the governing documents. So we talked about the declaration, the bylaws, the rules and regulations. And the board and the officers of the condo association have the obligation to follow the rules laid forth in these documents when making decisions. So if the board failed to give proper notice of a potential action they're taking or do a proper vote prior to acting, that would be a violation of the governing documents. If they failed to follow proper procedures to obtain a necessary vote, if they took action that violated the rules set forth in the governing documents, then those are all violations. It's almost like a breach of contract claim. They have a contract. These governing documents are a contract between the board and the unit owners. If the board fails to follow the documents, then they're in breach of their contract with the unit owners, and the unit owners have a claim against them for any damages that result from that breach. The defenses to these breach of governing documents claims are there's a couple of them. There's a business judgment defense, where if the board is acting in their best business judgment, they have a wide discretion to make decisions. So if someone's saying they were making bad decisions, as long as it's within the realm of the judgment as a pseudo business owner, then that's a automatic, basically, defense to these breach of contract claims. Another defense is reasonable reliance on an attorney. So if the board consulted with their attorney on what to do and their attorney gave them advice and the board then followed that advice, then that's a defense to claims against them for breach of the governing documents. A similar claim is breach of fiduciary duty. So the board and the association have a fiduciary duty to the unit owners to act in the best interest of the group as a whole and not to self-deal. So the elements of a breach of fiduciary duty claim are the existence of the fiduciary duty, which exists because of the status of the board member, a breach of that duty, so they violated their duty to act in the best interest of all the unit owners, and damages by the person claiming the breach. So the person who claimed the breach actually has to be injured. The duty itself is a duty by the board and the members individually to exercise care and act in the interests of the condominium owners. The claims can be negligent or intentional, and they can be against the board or against the individual members. So you can basically say the board accidentally breaches fiduciary duty or it intentionally breaches fiduciary duty, and you can also sue the board or sue John Smith, who is a member of the board, and sue that person individually for a breach of fiduciary duty claim. The one claim that you can't uphold is a negligent claim against an individual member. So you can sue the board for negligence, but you can't sue the individual member of the board for negligence, although you can sue them for their own willful and intentional acts. Another big dispute between condominium owners and the boards are use and occupancy restrictions on their condominium units. So the board's saying you can't use your condo for a particular thing, or a certain type of person can't occupy the condo. These use and occupancy restrictions are usually contained in either the declaration, the bylaws, or the rules and regulations, and they're typically upheld if they're non-discriminatory. A hot topic here that really blew up during the economic downturn after 2008 was the restrictions on the leasing of the condominium unit. So a lot of people wanted to get out of their condo, start a family, move to a house, but they weren't able to sell the condo because of the terrible real estate market at the time. And then they weren't also able to lease the condo because there was a restriction on the condo having to be owner-occupied. So a lot of people tried to challenge these restrictions, and whether that challenge was upheld or denied really depended on whether the membership voted in that restriction or whether the board did. So if it was a vote of the membership that led to the restriction is presumed valid, and it won't be overturned unless it's arbitrary, against public policy, or violative of some fundamental constitutional right. That's the standard. So it was really hard to overturn those restrictions if the members actually voted on them. If the board did it on their own without a vote of the full membership, then it's presumed not to be valid and only upheld if it's affirmatively shown to be reasonable in both purpose and application. So basically, if the board decided, hey, we're not allowing people to rent out their condo, and they didn't open it up to a vote of membership, it was a lot easier to overturn those rules and regulations. Also, if the board had any discretion in enforcing those rules and regulations, it's a lot easier to overturn the underlying rule and regulation, because you don't want to leave it in the hands of the board to decide who gets to rent their condo and who doesn't. Finally, the last dispute I want to talk about today is discrimination. It's unlawful to discriminate in the rules and regulations or in the enforcement of the rules and regulations in a condominium association based on race, color, religion, sex, or national origin. So even if the rule on its face isn't discriminatory, if the board is applying it in a discriminatory manner based on any of those terms, then whoever's being discriminated against might have a good claim against the board for discrimination. So those are the key disputes between a board and the unit owners, or the association itself and the unit owners. It's, the unit owner not paying rent, the board breaching its obligations under the contract documents, the board breaching its fiduciary duty, use and occupancy restrictions, and discrimination. There's a lot of other issues that are involved in condominium law, but those are the ones we see over and over again. So thanks so much for listening. If you'd like to see more videos, listen to more of our podcasts, read more of our articles on real estate law or any other area of law — we practice almost every area of law — you can go to learn-about-law.com, where we've got a whole bunch of articles, videos, and audio for you. If you'd like to schedule an initial consultation, you can call me at 630-324-6666. That's 630-324-6666. We're very experienced in both HOA and condominium association law, and happy to help you. We also have another podcast and video blog called seizeyourbusiness.com that you should check out, where we interview business owners. I want to thank Tom Weiler from Weiler Studios for doing our videography. If you would like to hire him to do a video for you or your business, or do real estate videos for you, you can go to weilerstudios.com, and that's Weiler with a Y. Thanks so much for listening.